Welcome to the Chicago Bar Association's Justice and Law Weekly. I'm Terry Masherin, Vice President of the Chicago Bar Association. During this program, we will be discussing the United States Supreme Court. The Supreme Court is the highest court in the land, and many of the court's decisions affect our rights as U.S. citizens. Joining me to discuss the court are two legal scholars, Dawn Clark-Netsch and Ronald Allen. Mrs. Netsch is Professor of Law Emerita at Northwestern University and former Illinois Comptroller and State Senator. Mr. Allen is the John Henry Wigmore Professor of Law at Northwestern University and is an internationally recognized expert in constitutional law. Welcome, Dawn and Ron.
Thank you.
Nice to be here.
Dawn, some of our viewers may not be very familiar with the Supreme Court and what it does. Would you explain to us what the court is and how the justices are selected?
The latter is easier than the first. Actually, the name really explains what it is. It is the Supreme Court of the United States. You know, just as, I suppose you could say that just as the president is the head of the executive branch in the federal government, the Supreme Court is the head of the judicial branch. And we always have to remind ourselves that we do have three fundamentally co-equal branches. That is, you know, the American way, and something that we feel very good about. An independent judiciary is one part of it. So that the Supreme Court is really, I think you could say, the final arbiter of any matters that involve or arise under the United States Constitution or laws, or for that matter, treaties that are entered into by the United States government.
And how do the justices get onto the court?
They are appointed by the president but always confirmed by the Senate, and that's where we've gotten into some rather strange circumstances in recent years. It didn't used to be always that difficult, but they are nominated by the president, confirmed by the Senate. And it's usually referred to as a life term. The actual constitutional language is that they are in office for good behavior, as long as they behave well. But we assume they're all going to behave well, and so that pretty much turns out to be life tenure.
Now, Ron, how does the court decide what cases to hear? They don't hear just any case that someone tries to bring before them, right?
Yes, well, there are technical restrictions on cases that can be appealed to the Supreme Court. Not every case can be. There has to be a federal question or a federal issue or federal jurisdiction. So, for example, typical issues in state courts, the final arbiter of that is the state Supreme Court, and there's nothing the Supreme Court of the United States can do. So the Supreme Court really isn't supreme in that sense. It's supreme only with respect to national or federal issues. There's an informal, what's called rule of four. If four members of the Supreme Court vote to hear a case, the case will be heard. They make that decision on the basis typically of what are called cert petitions that are filed in the Supreme Court. They and their staffs analyze these cert petitions, and then there's literally a vote. If four members of the court want to hear a case, then it will be heard, which is interesting because typically it's a majority that decides a case. So less than a majority of the court can decide to hear a case.
Now, Dawn mentioned that...
Can I ask Ron one question that I think is interesting? Ron, my understanding is that in the last few years, maybe several terms, the court has been taking and deciding fewer cases than it used to in the past. Am I right? And do you know why?
Nobody knows exactly why. You are absolutely right. At the height of its decision making, that is when it was deciding the most cases per year, it was deciding around 200, issuing around 200 opinions. It's now down to about 80. Now the 200 was the extreme, wasn't the long-term average, but it used to reside in the mid-hundreds. So really it's been cut in half. Now, why is that? No one really knows, because the decision-making is not public, it's private. And even when the justices publish memoirs and so on, or they don't really discuss this stuff, and they keep their files secret, usually for 20, 30, 40 years. So, so you don't really know what's going, you don't know what's going on. There are different views about the significance of this. Some people think it's a problem. Some people think too many Supreme Court decisions is a problem. And I'm not exactly sure which one I think is
Where you
right.
fall.
Yeah.
Now, we've had a change in the composition of the court this year. Dawn mentioned that justices are appointed by the president, and we have a new justice, Sandra Sotomayor, who's joined the court. Ron, can you tell us a little bit about her background and what she might mean for the court?
Well, she was a former prosecutor, interestingly enough, although obviously active in Democratic politics, and then a member of the Court of Appeals, and was appointed, I guess, by Clinton to the Court of Appeals. One thinks that she will probably be a vote quite consistent with Souters, who she replaced on a lot of issues. I think if there are going to be any surprises here, the surprises are going to be on the liberal side, not the conservative side. That is, I think that she may not hew the fairly standard liberal line that people think she might hew. And I say that because there are some enormously important issues facing the Supreme Court right now in terms of criminal prosecution, in which experience as a prosecutor will be tremendously invaluable in terms of the practical consequences of what the court is doing. Sometimes,
and she's the only former prosecutor on the court, right?
Yeah.
I think that's right, yeah.
Now, we have,
and
of course...
Unfortunately, I don't think anyone is on the court any longer who had ever been in elective office or in the state level, which Sandra Day O'Connor had been. And there's no question in my mind that that had an influence on her decision-making. I mean, she'd had a different set of experiences, and it made a difference, I think.
Right. Now, the longest-serving member of the court now hails from Chicago, and that's Justice Stevens, right? And Justice Stevens will turn 90 next year. Is there any word about him perhaps stepping down from the court?
Lots of words. Everyone is speculating about it. He seems to be the only one who's not concerned about it. I think a lot of it started with the fact that for the next term, he had apparently chosen only one law clerk, and typically they have 4 or 5. And so that was a signal, everyone thought, that he was getting ready to retire. I've seen him quoted once about it and saying, "I love my job," which didn't sound as if he was anxious to get out. I think the story also is that he still plays tennis regularly. His only concession to age is that he plays doubles now instead of singles. At least that is the story. We don't know. He obviously at some stage is going to retire, I think. And all I can say from my perspective, and I think from the perspective of a lot of other people, it's going to be an enormous loss.
Now, there was an unusual turn in the court this year. The court always starts its session in September. This year they came back early to hear re-argument in a case called Citizens United.
Yes.
The case centers around a movie called Hillary the Movie, which was attempted to be put out during the presidential campaign. Ron, what's the main issue in the Citizens United case?
Well, there are 2 different answers to that question. There's a technical issue, and then there's a speculative issue. The technical issue is whether or not certain restrictions on campaign expenditures are violative of the First Amendment. The First Amendment limits Congress's ability to limit what people can do in terms of campaigns for office. In this case, the limits are complicated, and I'm not sure you want to go into the details of it, but basically at certain times before elections, institutions, corporations, labor unions, and so on, are not allowed to fund certain kinds of activities. And if they fund a related kind of activity, then they have to disclose where the source of the funds came from, and so on and so forth. Did you want to?
Yeah, basically, it's the corporations and unions are prohibited from using their treasury funds, that is their corporate funds and their union funds, to finance what are called electioneering communications during the period that Ron talked about. And electioneering communications is a little bit broader than the law used to provide, which said that you can't use your funds directly to advocate the election or defeat of a particular candidate.